Welcome to the comment article reported by Nguyen from Institute of Intellectual Property and Competition for October 2021. And today we will discuss about a subject concerned to the partial reproduction. The leading precedent defined the boundary of the notion of reproduction in part is again Infopaq, as we discussed before. Here the court concludes that nothing in the Infopaq Directive or in any other relevant copyright relevant directive suggests that part of work should be treated differently than the work as a whole. This implies that any fragment may be protected if it contains elements which are the expression of the intellectual creation of the author of work. On the basis of the principle of high level of protection, recital 9 Infopaq and pro interpretation recital 21 Infopaq of exclusive right, also isolated sentences or part thereof may be protected by the exclusivity granted by the right of reproduction if they may be suitable for conveying to the reader the originality of the work they are extracted from, no matter how short. The notion of partial reproduction construed by the court is thus of the qualitative and not a quantitative nature. The same approach characterized the field of software program in SAS Institute. The CJEU ruled that the extraction of part of a source of object code to create similar element of a software in another one constitute partial reproduction under Article 4A Software 1, while the mere reproduction of the functionality of the program by using the same programming language and the same format of data files without the compilation or access to the source code does not infringe any exclusive right. It took much longer for the court to finally intervene on the long debate on the meaning of partial reproduction. In the field of related rights, particularly heated due to the threshold required for the protection of entrepreneurial rights against the higher standards set for author rights. Canham seemed to provide a final and stable response, focusing on the most controversial topic discussed by scholars and court, that of music sampling. The controversial reproduction concerned the use of 2 seconds of a rhythm sequence from the song Metal of Metal, authored by the group Kraftwerk in 1977, in Panam's song New Year, released in 1997. The main claims were centered on the infringement of the reproduction rights of the phonogram producer under Article 2 Infopaq, and the question raised to the CJEU were whether the copy of such a short sound sample would amount to a reproduction in part. The court ruled that a literal interpretation of Article 2 Infopaq militates in favor of coverage of any sound sample of a phonogram, even very short. This reading was also deemed consistent with the general Infopaq goal to establish high level of protection of copyright and related rights. And with the specific objective of protecting the phonogram producer investment by allowing her to obtain a satisfactory return. However, the CJEU found necessary to define the scope of the reproduction right also in light of the first balance to be struck between, on the one hand, copyright related right, and on the other hand, the fundamental right of user and the public interest. Since sampling is a technique used to produce a new work and thus to exercise the freedom of art, enshrined in Article 13 of the Charter of Fundamental Rights of the European Union, and covered also by Article 11 on freedom of expression. The protection of each exercise should be weighed against the protection of intellectual property under Article 17, which the CJEU reiterated, by no meaning attributed by absolute nature of IP right. On the interplay between copy and other fundamental rights, she answered the general discussion in Charter 2. On this basis, the court ruled that sample taken from a phonograph and used in a new work in a modified form, unrecognizable to the ear for the purpose of distinct artist creation, could not cover by Article 2 Infopaq, and this could not only run counter to the usual meaning of the work, reproduction, and to the case in view, but also to the requirement of a fair balance. The CJEU maintained, in fact, preventing sample even if the reproduction would not interfere with the free producer possibility to realize a satisfactory return on investment, would constitute a disproportionate violation of freedom of art. For the first time, the court defined the scope of exclusive right using the notion of fair balance between conflicting fundamental rights, which until this point had come into play only in the field of exception and intermediary injunction. So we can also see the format shifting, reproduction or adaptation. We have many things to discuss about other things like private copy and fair remuneration and other exceptions to the right of reproduction. So we can see that the right of reproduction is very complex issue, and we're going to conclude that differently than in the cases of the right of distribution, and even more of the right of communication to the public, the definition and scope of the reproduction right have not been subject to unexpected stretches of greater degree or overall in the past 2 decades. After the heated debate that surrounded in complex update and reform along the 1990s, in response to the advent of the internet and the increased spread of personal computer and the digitization of protected work, the most classic among the exclusive rights settled on an apparently very broad legislative definition. Commentator, activists, and policymakers fear that purely technical interpretation of the notion of reproduction could lead to attributing to the copyright owner the monopoly over too wide an array of conduct, regardless of their actual impact on the normal exploitation of the work. However, their threats were progressively dispelled by a relatively balanced definition of the notion of temporary and partial reproduction by the CJEU, which had adopted a cautious and mostly normative approach, limiting the scope of the right to what was necessary to ensure that right holder retain control over economically significant uses of their work. And a short of final act of saga, the court went even as far as to use the concept of fair balance between conflicting fundamental rights to set the boundary of Article 2 Infopaq, excluding that short sound sampling violated the reproduction right of producer of phonogram, and thus introducing into the teleological interpretation of the provision of an element of constitutionalization that had never featured field beforehand. Peter and criticism and most concern side products of the interpretation that the court offered of Article 2 Infopaq, etc. The definition of protected subject matter still affected by greater uncertainty and not effective circumscribed. However, this had not prejudiced the judicial development and the right of reproduction, which is still characterized by greater clarity and more balanced construction than the two orders specified and harmonized by the Infopaq Directive, featuring instead an often uncontrolled expansion which severely impact on the copyright balance. The role had to fulfill adjust Article 2 Infopaq to current time and technology is still rather long, yet the approach adopted by the GKU is promising. The draw path of legal certainty, while and teleological consideration of dichotomy, exclusivity, access, and stability in the doctrine and interpretation output that could be used, except for some flaw, as a role model for the construction of all exclusive rights. So we will see here many things related to this matter. So we will go back to the formal shipping. And already we discussed about partial reproduction in Infopaq and Panham. And now we go to the formal shifting, reproduction and adaptation. So you can see the problem of the right of reproduction is very complex and not really easy to go through this definition. So in order to understand clearly about the Infopaq Directive, we're going to discuss the case which is called Infopaq International versus Dagblades Forening. And so here's the case. 2007. We go to directly by the judgment. This reference for preliminary ruling concern first the interpretation of Article 2 of the Directive 2001/29 of the EC on the harmonization of certain aspects of copyright related rights in the information society. And secondly, the condition for exemption of temporary act of reproduction within the meaning of Article 5 of that directive. So, the reference was made by the contest of proceeding between Infopaq International A, Infopaq, and Dagblades Forening, DDF, concerning the dismissal of its application for a declaration that it was not required to obtain the consent of the right holder for act of reproduction of newspaper article using an automatic process, consisting the scanning and then convert into a digital file, followed by electronic processing of that file. So you can see here the act of reproduction of newspaper article. So they just photocopy it. And what is the international law? We have Article 9 of the agreement, of the TRIP agreement, set out some regulation, which were approved by the Cultural Commission concerning the conclusion on behalf of European Union as regard matter within its competent and agreement, which is good way around multilateral negotiation. And the members shall comply with Article 1 through 21 of Berne Convention, and so on. Article 2, the expression of literary and artistic work shall include every production in a literary, scientific, and artistic domain, whatever may be the mode or form of each expression, such as books, pamphlets, and other writing. So this case fall within the definition of the literary and artistic work. Collecting of literary or artistic work, such as encyclopedia and anthology, which by reason of the selection and arrangement of their content constitute intellectual creation, shall be protected as such, without prejudice to the copyright of each of the work forming part of such collection. And the protection of this convention shall not apply to new of the day or to miscellaneous factors have new character of mere item of press information. So under Article 9 of the Berne Convention, author of literary and artistic work protected by that convention are to have the exclusive right of authorizing the reproduction of those works in any manner or form. That is from the Berne Convention. So you can see the Article 9 of the Berne Convention. It just defines very clearly about everything concerned to the thing we have been discussed so far. So I will search for the Berne Convention to all the people to see how can we define a work under the Article 9 of the Berne Convention. Here the case. So the Berne Convention decides that author of literary and artistic work protected by this convention shall have the exclusive right of authorizing the reproduction of this work in any manner or form. And it shall be a matter for legislation in the country of the Union to permit the reproduction of such work in certain special cases, provided that such reproduction does not conflict with the normal exploitation of the work and does not unreasonably prejudice the legitimate of the author. So that's the case. Now we go back to the decision of CJEU on the matter, Infopaq case. So from the international background, the court mentioned about the Berne Convention and especially Article 9 of the Berne Convention. So what we see in the community law, we have Directive 91 on the legal protection of computer program. And in accordance with the provision of this directive, member states shall protect computer programs by copyright as literary work within the meaning of Berne Convention for the protection of literary and artistic work. The computer program shall be protected if it is original in the sense that it is the author on intellectual creation. No other criteria shall be applied to determine its eligibility for protection. So you can see the actual Article 3 of Directive 96 provide below. In accordance with this directive, databases with by region of selection or arrangement of their content constitute an author on intellectual creation shall be protected as such by copyright. No other criteria shall be applied to determine their eligibility for that protection. So the directive 2001 in the purpose to harmonize the copyright measure within the European Union. So they will define what is the exception, not conflict with the normal exploitation. And also they provide the definition of photograph, which is original in the sense that their author or intellectual creation shall be protected in accordance with Article 1, which specify the duration of the right of an author of a literary or artistic work within the meaning Article 2 of Berne Convention. No other criteria shall be applied to determine their eligibility for protection. Member States may provide for the protection of the photograph. And here the case. So dispute in the main proceeding and the question refer for preliminary ruling. That's a very famous ruling when we refer the case to the European Union. Infopaq operated media monitoring and analyze business, which consists primarily in drawing up summary and selective article from Danish daily newspaper and other periodicals. The articles are selected on the basis of certain subject criteria agreed with customer, and the selection is made by means of a data capture process. The summary is sent to customer by email. So that's case is why you summarize information and you analyze and then you will send to your customer. The DDF is a professional association of Danish daily newspaper publisher whose function is inter alia to assist its member with copyright issue. In 2005, DDF became aware that Infopaq was scanning newspaper article for commercial purpose without authorization from the relevant right holder. Taking the view that such consent were necessary for proceeding article used in the process in question, DDF complained to Infopaq about this procedure. The data capture process comprises of 5 phrases described below, which, according to DDF, lead you for act of reproduction newspaper article. First, the relevant publications are registered manually by Infopaq employees in an electronic registration database. And second, one, the spinner cut off the publication so that all the page consists of loose sheet. The publication is scanned. The selection to be scanned is selected from the registration database before the publication is put into the scanner. Scanning allows the TIFF task image file to be created for each page of the publication. When scanning is complete, the TIFF file transfers into OCR, article character recognition server. Third, the OCR server translates the TIFF file into data that can be processed digitally during that process. The image of each letter is translated into a character code, which tells the computer what type of new letter this is. For instance, the image of the letter TDC is translated into something the computer can treat as the letter, the TDC, and put it a text format can be recognized by the computer system. These data are saved as a text file which can be understood by any text process program. The OCR process is completed by selecting the TF file. And 4, the text file process to find insert word defined beforehand. Each time a match for several words is found. Data is generated given the publication section and page number on which the match were filed together with the value expressed as a percentage of between 0 and 100, indicating how far into the text it is to be filed in order to make it easier to read the article. Also, in order to make it easier to find the research word when reading the article, the 5 words which come before or after search word are captured. Extract of 11 words at the end of process, the text file is deleted. Fifth, at the end of data capture process, over sheet is printed out, and in respect of all the pages where the relevant search words were found, the following is an example of text of a cover sheet. So you can see below. So they just scan the word. $11 words, you can see here. Infopaq dispute the claim that the procedure requires consent from the right holder and brought an action against the DDF before the Australia's Eastern Regional Court, claiming that DDF should be ordered to acknowledge that Infopaq is entitled in Denmark to apply the above mentioned procedure without the consent of DDF of its member after the Ost land rest. This made that action Infopaq brought an appeal before the reference court. So according to the Højesteret, it is not disputed in the case that consent from the right holder is not required to engage in press monitoring activity, and the writing of summary consisting of manual reading of each publication, selection of the relevant article on the basis of predetermined search word, and production of a manual prepared cover sheet for summary writer, given the identified search word in an article and its position in the newspaper. Similarly, the party in the main proceeding do not dispute that generally independent summary writing procedure is lawful and does not require consent from the right holder. Nor is it dispute in this case that the database capture process described above involved to act of reproduction. The creation of a TIFF file when the printed article is scanned and the conversion of TIFF file into a text file. In addition, it's common ground that this procedure intended for production part of the scanned printed articles in the extract 11 word is stored, and those 11 are printed out on a paper. There is, however, disagreement between the party as to whether that is reproduction as contemplated in Article 2 of the Directive 2001. Likewise, they disagree as to whether, if there is reproduction, the actor in question, text as a whole are covered by exemption from the right of reproduction provided in Article 5 of that directive. So, here the question we need to resolve during these problems. We have around 13 questions. 13 questions. The first question is, can the storing and subsequent printing out of text extract from article in a daily newspaper consisting of search word and 5 preceding and 5 subsequent words be regarded as of reproduction which are protected, see Article 2. Second question is the context in which temporary acts of reproduction take place relevant to whether they can be regarded as transient. Article 5 Directive 2001 and 29. And 3. Can a temporary act of reproduction be regarded as transient, where the reproduction is processed, for example, by the creation of a text file on the basis of image file, or by search of text string on the basis of a text file? 4th, can a temporary act of reproduction be regarded as transient, where part of reproduction consisting of one or more text extract of 11 words is stored? 5th, can a temporary act of reproduction be regarded as transition, where part of reproduction consisting one or more text extract of 11 words is printed out? 6. In the state of the technological process at which temporary acts of reproduction take place relevant to whether they constitute an integral and essential part of technological process? 7. Can temporary act of reproduction be an integral and essential part of technological process if they consist of manual scanning of entire newspaper article whereby the latter are transformed from a printed medium into a digital medium? 8. Can temporary act of reproduction constitute an integral and essential part of a technological process where they consist of printing out part of the reproduction comprising one or more text extract of 11 words? 9. Does lawful use in Article 5 Directive 2001/29 include any form of use which does not require right holder consent? 10. Does lawful use Article 5 include the scanning by a commercial business or entire newspaper article, subsequent proceeding of the reproduction, and the storing and possible printing out of part of the reproduction consisting of one or more text extract of 11 words, or used in the business summary writing, even where the right holder has not given consent to those acts? 11. What criteria should be used to assess whether temporary act of reproduction have interdependence, economic significance? See Article 5 in the order condition laid down in provision of are satisfied. 12. Can a use efficiency gained from temporary act of reproduction be taken into account in assessing whether the acts have independent economic significance? See Article 5 Directive 2001. And then the last question, can the scanning by the commercial business of entire newspaper article, subsequent proceeding of the reproduction, and the storing and possible printing out of part of the reproduction consisting of one or more text extract of 11 words without the right holder consent be regarded as constituting certain special cases which do not conflict with the normal exploitation of newspaper article and not unreasonably prejudice to the legitimate interest of the right holder? Article 5 Directive 2001. So that is the question we need to resolve in this case. So now I think you can take some time to think about that, and we'll see you in the second section. Nguyen Cuong report from Institute of Intellectual Property and Competition, 4th October 2021. Thank you, and see you in the next section.